Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Welcome back to White Hat Law. My name is Warren Nord. I practice law in downtown Arlington, and today we've got a good show for you. We've got Brian Kissel. Brian Kissel is a platform independent consultant architect. I'm reading this right. But what that means, he knows about cyber stuff. And so, used to be with IBM, now with Calypso here in Tarrant County, right? It's Tarrant County.
Yep,
Absolutely.
right here in Tarrant
And so, used to work with Department of Agriculture.
I did.
And the UN.
I did.
We'll forgive you for that, but it's okay. Today we're talking about cybersquatting. We're talking about the regulatory issues surrounding cybersquatting and cybersecurity. So, Brian, what is cybersquatting?
So cybersquatting, it's also known as domain squatting, is a practice, and we have to define this as a malicious practice, right? Because there's intent behind the rules here. But it would be maliciously going out and buying up or registering a domain name with the intent of using it for nefarious purposes, either capitalizing on the name of a celebrity in order to increase traffic, or misdirecting unsuspecting users. Also cybercrime like phishing and those specific kinds of attacks may dress up. There's a type of cybersquatting that we call typo squatting. Like if you had Bank of America, but you misspell America, and then someone goes there, but the pages look very similar, and they attempt to log in, you've not got that password right. So that's
Facebook
another malicious
with an
practice.
S? Yes.
Facebook with an S would be a great example of that.
Yeah. Okay, so you said nefarious, though. Well, how does that work?
Well, there's a legitimate practice called domaining, and that would be from an investor's perspective. If you were to analyze market trends and you were watching for future use and then decide to register domains for related products or fields that you believe will have a surge in activity, that's a legitimate interest, and you're not doing it with a nefarious purpose. The intent here is to buy up domains that would be related to an emerging market. A nefarious purpose would be like the famous case with Madonna, where you register Madonna.com and then leverage that misdirected traffic to an alternative either sites to get money off of advertising or try to promote other products or sell them other services.
Now, Tom Cruise had a big case on that. Tell us about that.
Tom Cruise had a super big case of cyber squatting. This guy's name was Berger, Brian Berger, I believe, and he was known far and wide with WIPO, which is the Worldwide Intellectual Property Organization. They had tons of complaints about this guy, and his thing with Tom Cruise actually went forward with a full lawsuit because Tom Cruise was willing to go after the guy. It wasn't a buyout opportunity. So he had TomCruise.com, and it was redirecting to his personally owned celebrity news site, and he was leveraging the Tom Cruise traffic to direct those folks to Tom Cruise news that was not necessarily libelous. It wasn't artificial or inaccurate. It was legit celebrity news, but it was also an advertised-driven site. So he was collecting revenue on that traffic. And Tom Cruise, of course, late to the ballgame, he wanted to register his domain name. And his attorney, of course, argued that Tom Cruise should own TomCruise.com. He has an infallible right to his name and his brand. He's super famous. And their big point of contention was that people will be confused. Tom Cruise is either affiliated with this site or supports this site somehow, or they're getting their celebrity news from Tom Cruise, right? And the courts did agree with them, but of course Berger's argument was no, and he tried to argue that free speech came into it, and there was a disagreement there, right? This was all profit-driven, and it was profit-driven at the expense of Tom Cruise. So he was defended, but that was a big one.
We see the same problem when people take pictures of famous people in public places. Now it's pretty much established. You can take a picture of a famous person.
Yeah, that expectation of privacy.
Yeah, but if you are not in a public place, or if there's restrictions on what people expect, right? And so if you say, I'm looking for news from Tom Cruise, and TomCruise.com surely is owned by Tom Cruise, or it's going to be affiliated with him. So, but it makes for an interesting case whenever the guy's really he's not trying to mislead people. He's just trying to capitalize on that traffic.
Like he had bought that exit ramp and felt totally entitled to the traffic on that toll road, right? And I get that, but in the same respect, there is that expectation of ownership of your own name, and I think we'll talk about this again further into the show, right? But it's 2018. You have an expectation that your .com is not going to be misrepresenting your interests or even owned by someone else. You may choose not to put material or data up there, but that doesn't mean you're making it available for other persons.
Just because I'm not using my bed right now doesn't mean that you can come in and use my bedroom.
Yeah, exactly.
Well, you left the door open or something else. But you see that a lot with, and I do a lot of trademark work where people have had businesses for decades. and they wake up one day and somebody else, who's some upstart in another part of the country, has registered the trademark for their business. And they didn't necessarily, the other business is not necessarily trying to glom on or take their market share because they're not really competing, but it's a small world, right? So you register your trademark, or somebody else takes it, and then you got this big fight over who gets to use it, and this other person stop you, even though you've been doing business a lot longer. So it's one of those things where attorneys are a lot cheaper in the front end and get your trademark now.
Yeah, absolutely. An ounce of prevention is worth a pound of cure.
Right, several pounds, yeah. So what does it take to fix this problem?
That's a really interesting question. I think when we look at the scope of cybersquatting and the offshoots of it, right, we have to look at the purpose, and really it's hijacking, right? It's
Right.
essentially blackmail or kidnapping, whatever your pejorative term is for seizing this asset and then demanding money for it. There are other tricks people can play too. There's a thing called domain kiting, which is attached to this, where the WIPO, the same group, has established this 5-day grace period. If you accidentally misspell your domain name or you accidentally registered something, this whole system was built in the beginning, where you have 5 days to try and roll back on that. But again, with nefarious intent, you could try to register an opponent's domain name that you've lost this legal fight with, and then in 4 days try to delete that registration and then apply again, and create this like rolling snowball that never gets resolved, so nobody can get their domain back and capitalize on it, even though you've legally lost control of it. The practices around this, they hit that gray line again. And as an attorney, I'm sure you can respect this, right? The thing called grief sites, where I have a domain very similar to the spelling of your name, and I in fact have images of you and content that relates to you on it, but the intent is parody. And if we can establish that this is a parody site, then we move outside of that.
It's very difficult to stop that.
It's super hard to argue about that. We see that in other forms of media as well, and of course that's translated to the internet. So I think we're right in approaching this from an intent perspective, but enforcement is difficult and it needs to be broadened. When we look at ICANN, you have to open a complaint with ICANN, and then they go through a very arduous and time-consuming process to talk to the other registrants and talk to your domain hosts and try to get the issue resolved and get the site torn down. That is exceptionally long and difficult and expensive.
I have a consultation with somebody probably every 2 or 3 weeks about something like this, and I have to explain to them the long process for going through this. And it's not huge dollars, but it's easily more than $1,000 and approaches $5,000 to really resolve something like this in a legal way. And if they really want to fight back because they have a better defense than most people do, usually I saw that this was an open URL, so I grabbed it, and now I want you to pay me $200-300 for it. Usually, it's easier just to. That's why you can usually buy them for less than $1,000, right?
Pay the ransom.
You pay the ransom and get it go, right? But sometimes, there was the VW.com. That was one of the early ones, So, but that was a dealer, right? It wasn't actually VW, but it kind of was.
It was, and it wasn't, right?
Right.
In any other transaction, the VW one's an interesting case because it speaks again to that licensing idea. Who has the right to do this? We are licensing you to sell our cars. You have our lot. You can use our branding. You are a franchisee for all intents and purposes. However, this insular single domain name, that is ours. It is immutably ours, and we will fight you for it. I think that's why we're going to see the future of legislation, the way we protected companies so far, begin to protect individuals as well.
Well, we do this when you go to law school and you talk about property. We talk about the sticks of the bundle of sticks that goes along with property, and we talk about some property you own you can't sell, like your prescription drugs. Some property you can. When you rent something, you have the power to do certain things, but you don't have the power to have sometimes commercial business with it. So we divide these elements of property up very closely, and in copyright we've done this very well, where you pay a certain amount of money to perform a song that's already written.
Sure.
You pay a certain amount of money to have music over the airwaves, and your smaller business pays less than the bigger business. And so
bulk licensing fees from large collections.
Right.
Yeah, sure, easy ways to go about it.
Right. So there's lots of little things we do. I think we're going to see this differentiation on, and it has to be.
You would have to see it, yeah.
Because we're going to have to see, because you're going to have situations where, NORAD, FamilyNORAD.com, and it's going to be everybody that's related to me, right? And I put it in there, and somebody else has got a NORAD family, and they say, well, you're just going to have a lot of very nuanced, muddy edges.
And I think those nuances will resolve themselves with, And I hate to sound like a hippie about it, right? But what makes you uniquely you? And we'll start to see that expressed in our registration and occupation of domain names. I like to use the term digital citizen, and we all are. And as we establish ourselves as digital citizens through social media and the softwares and the platforms that we use, you create a digital footprint. That's uniquely you. And we know this exists. There are advertising companies spending millions of dollars to seize the data in your digital footprint just to market to you every day.
Well, and it's true. You go somewhere, and if someone has to show your ID, I can pull up just pull up me on Facebook, and you'll see me, right? And unless it's something that's legal, if it's somebody who just needs to know who you are, then they go, okay,
that's an entirely different show. The authentication of personhood, we can get some futurists on the show and go into that for days. It's a remarkable topic.
Right.
For right now, in the real, right, we have URLs and we have online presences and social media presences that combine to produce a part of our identity.
Right.
I don't even know where I'm going with this, but I feel very passionately about the fact that all of these data elements combine into a data set that for any other intent or purpose, if it was in any system, it would be viewed as personally identifying information. This needs to be protected and secured. This is a protected class of data regarding an individual citizen. And if we view it that way for business, we must be just on the cusp of viewing it that way for persons. That it should be protected and individually owned, and no matter what circumstance you're in, you should have access to that data and the ability to either edit it, correct it, request erasure. Maybe you don't get that request granted or not, but you should have that ability.
Well, let's put that on hold for a second. Let's take a break for a second. We're going to come back. We'll talk about government responses to and regulation of, and what should we be doing, and what has been done.
Awesome.
So we'll be back in a minute.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Welcome back. In this segment, we're going to talk about the regulations of the web and domain names and information that has to be kept, monitored, regulated, and protected. Let's start with the top and go down. ICANN. What is ICANN?
ICANN, I've actually got some notes for myself here, so I don't get any of these acronyms messed up. But ICANN is the Internet Corporation for Assigned Names and Numbers, and they are kind of an independent consulting body that speaks to the regulations and the deployments of system names and numbers. And they work with another group called the World Wide Web Consortium, the WC3. And these folks structure the rules that the internet runs on. When a major change occurs, the most recent of which people might be familiar with is the expansion of domain tag-ons, right? Like we've now got .info and as they stretch those out because we were running out of domain suffixes, these are the groups that make those determinations. They decide what the next ones are going to be, and they help define the engines that do these lookups and perform the operations that let all of these systems work together, right? So while they're not official in any capacity, their inputs make them pretty official.
I always look at those bodies as kind of like the four elements of the ancient Greeks. This is the fire, earth, water. These are the guys that
pretty similar, really.
It's kind of mythological.
And they're still mythical to this day, right? Because nobody really knows who's in the W3C.
We just know that these guys are important and they control a lot of stuff. Okay, so. And then we have registrars that take care of that.
Registrars are your middlemen. You pay them a small fee, and then they go through the process of registering a domain for you and ensuring that it's tagged to the official owner. But you got to watch out for that. Just as a side note, GoDaddy and services like that, make sure that you're listed as the record owner and not them as registering it on your behalf or whatever.
Right.
There's a tip for you.
Yeah. So I tend to use GoDaddy because it's cheap, and but there are lots of them to do this, and so
tons of registrars out there.
What's that?
Tons of registrars out there.
And so, and then what regulations do I have? Let's say I'm putting together a website, and I'm going to have, in fact, I have a client who's right now dealing with the GDPR.
The GDPR. So
the latest regulation that we have to deal with. What's that?
That's an interesting question, if I heard it right, because it begins this way a lot. What do I need to do to be compliant with X? And that's an awesome question. If we're referring to the GDPR, you have to do a whole lot. That's a European standard, and it stands for the General Data GDPR, General Regulation of Data Protection. and it is designed to give companies a framework by which they protect the data assets that identify individual persons in their systems for any reason. Typically, and the way it's written is really for people that do marketing. If you're going to reach out and call someone, send them an email, put them on a direct mailer blast, whatever it is, you have to be GDPR compliant with these people. And
Which basically just you have to make sure that they've given you
they give you permission
to contact them.
to contact you, and they frame it in such a way is that you have to grant the company permission to process your personal data, by which like nobody is sitting down, pulling out a list or a Rolodex, handwriting a letter, and then sending it to an individual person, right? It's being processed by automated systems. In order to do that with the personal data, you have to get permission from these individual people. We have similar things in the States. HIPAA is a good example.
Because we didn't really talk about it. Who put out the GDPR?
The GDPR, an entirely new governing body was actually established throughout
And why
the European
would
Union.
we need an entirely good new government
The
body?
bureaucracy is absolutely crazy, and like we could get into this in depth as well, but it actually extends all the way down to the member states and how they're performing enforcement and some of the delays. But in general, a body of representatives from all the member states got together and then leveraged a few existing models, including the European Medical Device Regulation Platform, and they established a platform of protections, kind of a bill of rights for consumers whose data is being leveraged in any way. They included education and research firms, they included medical research, they included direct marketing. If your information is logged for any purpose whatsoever and it's relatable to you, then it qualifies for the GDPR. It made news, and you might, like everybody that logs into the internet for the past few months, right? No matter where you go, no matter what you do, you have to click yes. You've updated your cookie policy. Okay, I get it. Yes, you've updated your privacy policy. It's become kind of a joke now, but it's because of the GDPR. They are leveraging the biggest fines anybody's ever seen for this kind of enforcement ever.
And what member states, put it this way, is the United States a member of this?
The United States is not a member of this. It applies specifically to the European Union. However, they have specified that if you deal with the data of a European citizen anywhere in the world, you must be GDPR compliant. And if you're not, they can come after you to pay those fines that they've dictated, or they start to hassle you with your business relationships in Europe, which is really where things get tricky, right? If an EU member state, if the EU governing body has a problem with a specific business and they're doing business within the member states and you refuse to pay your fine, then they can start leveraging tariffs or other disciplinary actions against you on your import process, and it becomes almost unsustainable in cost. So that's the way it's designed to force enforcement, even if you're not within the EU. So if, let's say, you're a production house here in the States, but you've got clients in the EU, or you're broadcasting advertisements to the people in the EU, you absolutely have to be GDPR compliant.
Okay, so yeah, so it really shouldn't apply to ordinary, small, like, I wouldn't say Nextdoor because that's a big organization now, but if I had a small listserv serving, Southwest Arlington,
you'd probably be safe, right? This is when I consult my clients on this, and I'm a GDPR expert. You have to ask: is the juice worth the squeeze? If you're going to be in a position where a European citizen, for some reason, demands access to your data records and raises a fit if you can't provide it, right? What's the likelihood of that occurring? For some of my corporate clients, that likelihood is very high. Yeah. For smaller businesses, for locally owned interests, that likelihood is probably very low. And if you want to adhere to these standards and say that you're compliant to the best of your knowledge to all of these outlying governing bodies, then that's great. And it's 2018. It's fashionable to be secure. Data privacy is hot. Like, it's cool to be secure of that data. Then, more power to you. Go out there and do it. If you're dealing with European citizens and you decide that you're just small enough where you might be able to fly under the radar, I would suggest you reconsider, again, that ounce of prevention over the pound of cure.
Well, for a lot of people, for people who are new entrepreneurs, I see this in trademark world too. What do we have to get registered? Well, you could register a whole lot of things, or you could just the first thing you have that's used most prevalently. But if you've got a blog that's dealing with the kinds of cows you see in Texas, then it's lower in the priority.
Maybe the language of the GDPR can put you at ease from that perspective. Yeah. The actual phrasing, it's very broad, right? And I think ambiguous with that purpose in mind.
Bureaucracies like to be able to grab more territory as they go on. Right?
We'll let you all work it out, right? We leave it broad, and then an incident will occur, and the lawyers step into court, and then we start to figure out those granular finite rules, right? As it stands now, the The definition is that you have to deploy security measures equal to the risk of exposure. And that I'm paraphrasing, but it's super close, I promise. And what that means is like your blog about cows in Iowa, if the exposure of that data, if your site's busted wide open and all of your internal data is released, what's the risk of that exposure compared to, say, a local doctor's office or a dentist's office who's recording PHI? Incidentally, small customer base, but still, the risk of exposure there is wildly different. And you're expected to reasonably know that.
Right. Well, that's a good, of course, segue to HIPAA, right? So what's HIPAA? We always hear this stuff.
HIPAA is a lot like the GDPR, with two exceptions. It's specifically about what we call PHI, personal health information, and it is self-enforcing. And that's a good way to describe the way we do this in the United States. The GDPR has a group of people who are enforcers. They'll perform audits. They're out looking for violators, and they want to enforce the rules. They have minimum standards they expect you to adhere to. We don't do that here. HIPAA is our official government statement that we will deal with infractions on a case-by-case basis, but in general, we expect you to secure patient data to the best of your ability. What does that mean, though? What's the best practice for securing private data? There are encryption standards that we could apply. There are super data, like FIPS standards, the government information security standards we could adhere to, but no small business can afford to do that, nor would they invest, the time it takes to do that. Where's the middle ground? And I think it really comes down to when the breach occurs, not even whether it'll occur, because eventually it will, no matter what.
Right.
It's when that breach occurs. Have you invested enough to prevent it? And the answer is always going to be no. And I hate to make light of it and turn it into a joke, but like that's the reality of the situation in the environment for HIPAA. My favorite HIPAA story is my own doctor's office, where when you go and you sign in and it says, for HIPAA compliance, please don't read the name who signed in above you. And, like,
and what do you do immediately?
You look. You can't not look. You glance the whole list.
Or every other line you want to say, I told you not to read this.
But that's a self-enforcing mechanism of the HIPAA standard we have here in the States. And really, when you think about it, what do you have here? A list of the personal names of people who have come into this doctor's office. If you're at a specialist, then you know what their specialization needs were. When you start applying people like me who do machine-like thinking and enter these into data sets, you can extrapolate a lot from just
there was one story where there was a fellow who nobody actually broke any rules, but they could use where just what was out there, and they could find out his entire schedule, and they could figure out what his health condition was by the people he visited over the courses of a month or something.
Absolutely.
It's just not that hard, right?
One of the current use cases for this specific kind of research revolves around your toll tag, and it happened here in Texas, is we can determine based on where your toll tag, when and where it gets scanned and what direction you're going, typically what speed you're going based on the time it took you to get from one scan to another, right? These high-level elements can break down the entirety of your day, pretty much what neighborhood you had lunch in, what you did after work, what your likelihood is to go to Target on a Tuesday, based just on what we can glean from your toll tag information. So the GDPR looks out for that specifically. When they talk about the metadata of systems related to individual persons, when it comes to medical stuff, if there's a database that might exist of who saw this one specialist, then that far left-wing outreach still qualifies for data protection. And it's because of the breaches we've seen and the extrapolation of that data and some of the future breaches that it leads to. And I think that we're going to see the United States follow suit pretty quickly. We had that massive breach with that Florida company just this year. I believe it's Experis or Exactus. They were a marketing firm that did nothing but collect huge amounts of personal data on individual citizens, and the high-level analysis we've seen so far is that it includes your spouse's name, your kids' names, their age, where they go to school, where you work, sexual preferences, political preferences, and Facebook like counts. That's insane. From Facebook like counts alone, we're talking about databases people pay millions of dollars for access to in order to market directly to you, and these cats are just creating profiles for marketers. That information got leaked. If you are an adult American, your person, that profile of you, that dossier is out there. And unlike the GDPR, where you're granted this right to demand the company show you what information they're peddling that relates to you, we don't have that yet. And now we have a perfect example of why we need it.
Well, there are those of us that, and you may or may not be as public or as open as I am, but I run an open Facebook site. I've got a LinkedIn that's pretty extensive. I've got, I've got everything. I think I have it's MySpace anymore, but at one time, all the way back, if you want to, you can recreate my life. And it's not that hard. And that's going to be true for most. I wouldn't say most Americans, but lots of them.
that chain of history is actually a remarkable example of the problem we see in adopting to this issue in the future. Like my dad is a data officer for a very, very large bank, and one of the issues they continue to struggle with, they've never been able to resolve, is the authentication of a person. How do you authenticate who this person is? If you get online and you recreate enough of the back chain of an individual person, you can get through that frontline security measure to authenticate who you truly are. We talk about biometrics, if you want to take it Orwellian and talk about the microchip in the hand, right?
Right.
Even at least then, there's this unarguable establishment that you are who you are.
Right.
And without that kind of integration, we're marching into this blind.
Right.
Anybody could pretend to be anybody else. Domain squatting is just an example of that. And like
Yeah,
said,
it's the very beginning of that, right?
it's the beginning.
Right.
And like we said at the beginning, it's reasonable. And people now, young people especially, the next generation will expect that to be theirs.
Right.
Their .com is theirs. Their .info is going to be theirs in their mind and in practice. And for all intents and purposes, fundamentally, it should be.
I got my first cell phone, or not my first one, but one of my later ones, by walking in toward the very end where you could go through the pages and you could check out your Facebook. So the last four of my cell phone is 9999. And I said, that's going to be my cell phone number for the rest of my life.
That's awesome.
Right? And it's going to be cool. And everybody who's known me for 30 years knows can find me in my cell phone. And it's something I could actually gift my grandson if I wanted to.
Inherit the Quad 9s. That's awesome.
Yeah, it's cool. Or they can fight over it. If I don't ever will. But that's the highest and most public part of my data. And there's a whole lot more to that somebody can use once I'm gone, or misuse when they have access to it. But let's take a break, and we'll come back. We'll talk about some of these problems and maybe some answers to it, and what legally can be done when somebody has this issue.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Okay, welcome back. In this last segment, what we're going to do is we're going to talk about the Cybersquatting Act of 1999, I think it is, and what you should do when you see a problem in your life regarding either a URL cybersquatting problem or something that's nefarious going on the internet about your life. So, Brian, what do I need to know about the Cybersquatting Act of 1999?
Well, the Anti-Cybersquatting Consumer Protection Act of 1999 was
the better name, I guess.
The full name, right?
Yeah.
It was legislation introduced to protect this specific kind of activity, or protect people from this specific kind of activity. And again, in classic fashion, super broad, but I can do it verbatim. It creates action for registering, trafficking in, or using a domain name confusingly similar to or diminutive of a known brand. So it sets that stage immediately. It's related to IP almost exclusively.
That sounds like trademark enforcement language.
Very close to trademark enforcement. And I think it relates to some of the most famous cases we've had. When we look at the Tom Cruise example from before, Paris Hilton had an incident that she won in court, and Madonna's super famous incident, which fed into this law being enacted, when even if you have a legitimate business interest, or you could try to argue, right, that you had a legitimate business interest to leverage this name, if it infringes on the rights of the natural holder, the copyright
The reasonable
holder.
person looks at this and says, is Madonna.com related to Madonna or Tom Cruise?
Or Tom Cruise,
Yeah.
right? And that confusion has to exist. Like Joe Smith may not have the same grounds to argue that he owns the right to this property the way someone very widely known would be. But this law was designed really to protect corporations and brands. And I don't want to be insensitive about it, but like Madonna, the pop star, Tom Cruise, the movie star, is a brand. It's not an individual person. It's a corporation. So we're protecting those elements. The GDPR is an example. That is focused on individual persons to protect them from business entities and their misuse of data. For the Anti-Cybersquatting Consumer Protection Act, it was a long time ago. I think a refresh may be necessary. The technology hasn't really shifted, but the expanse of the practice and the sub-practices like kiting, those have changed, right? So maybe a reanalysis of this legislation would be wise. But in general, it doesn't help you, the consumer. What you really need to be looking at is ICANN, and again, another acronym for you, but the UDPR, their Universal Dispute Resolution Process. And that is really what an individual person can do if, let's say you've just started a small business, really, to be realistic, right, it would be more applicable to your small business than to your personal entity, unless you had some explosive like hip hop single hit the internet and all of a sudden you were famous on YouTube, right?
Right.
Then you can start to leverage these rules. But in general, we need a marketplace, and that marketplace needs to be confused by the misrepresentation of the brand,
Right.
or for that, and there have been examples, right, where someone registered a domain earlier, they had a much smaller business, but then they were overrun by a similar name and they got swallowed up. In those cases, compensation may be considered, right, but in general, you could fight that down and try to soak those in as well.
Well, you see this happens in the political world where somebody's running for office and they're more savvy, and so they go off and they buy their opponent's name, which a certain president of the United States did to a certain senator here locally for a while, and so.
And you'd think he'd know better. Trump's another interesting example. Right before he opened Trump Dubai, they made a big announcement, and he was branching out, and they were going to do China. I believe. I'm actually not sure where it was, but it was a major China hotel, Dubai, and then a third. And some jokesters got in and had purchased 3 domains out from underneath him, very specifically Trump Dubai, the 3 locations he had announced. And they filled them with parody material and tried to argue First Amendment protections and that it was parody sites. But again, for the way this breaks down, right, the court had decided that the specificity of Trump name plus location qualified. That was close enough to the trading mark that we had to consider that property of Trump, and that this was infringing on his rights.
It's
but
a whole lot
would have
easier,
known better because he'd been through it.
It's a whole lot easier to win these if you're famous and have a lot of money and
well-funded,
and you can take care. In fact, that's what we run into all the time when somebody comes in and says, "I want this website," and this person's grabbed it and won't sell it to me, and they want thousands of dollars, and I'd say, "Well, to file this,
let's talk about my hourly rate.
It's going to be $2,000 or $3,000, right?" And so. Now, it may be that we're lucky and we can get it done for $2,000, but the filing fee is nearly $1,000, or right around there. And so, just to get to the batter's box is going to be a couple grand. And so, if it's not worth it, then you just pay them, and you learn your lesson.
I think that's why we've seen a shift. These large megastars, these big corporations have the resources to fight against this kind of extortion.
Right.
Whereas that $1,000 ask, or just in the neighborhood of what the filing fee would be to take action against it, that's going to be the target that you see.
Yeah, it becomes the price for all of the URLs.
And really, it's a crime of convenience, right? I'm asking for a just cheap enough extortion for this to be appealing. And that's really the crappy nature of this. That cybersquatting is the worst because it's nitpicking low-hanging fruit from folks that shouldn't be paying it out anyway.
Right, that's right. You should have never owned this. So I enjoy those fights. But quite often, what you have is you have more simple things. Somebody has grabbed a Facebook page and now they won't let go of it. We have a case right now in the Republican Party where we have a past chairman of a county that had county chair GOP, and now he won't let go of it, but he's not that guy anymore, and so the next guy should get it, but he won't let go. So
that's another interesting platform. I think the president, again, to come back to him, is a good example of that. The Twitter account passes hands, right? And it should move with the office.
Who pays for it, right? That's kind of that's one of the questions. Who paid for this? Who set it up?
Who's got the license for it?
Right. Yeah.
Obviously, the guy with the title, right? And that you'd think that reasonably that's the way it should work out. We don't have simple answers to this stuff, which is why it's always a drawn-out fight to try and get one side over the other. With social media, we're breaching on some sensitive ground, right? Like, Facebook is not a college campus. It's not a protected place where you can go speak freely. It's a service. It's a service that you agree to terms of service to use.
Right.
You're enlisting in a marketing platform when leveraging social media. To assume that these protections extend there is very difficult for me, with one exception, and it is the personal identification exception. If you have a personal profile, or someone has built a personal profile to mock you, mimic you, or try to confuse people into thinking that they are you and then damage your reputation, should be approached the same way we approach identity fraud.
Right.
It absolutely should be. But we talked about it earlier, right? That's the reclassification and acceptance of this data being personally identifiable and being highly valuable. It needs to be treated as a commodity, a valuable commodity.
Well, it's a crime in Texas to do that.
And it should be. It should be a federal crime, really. consumers across the
Criminal
board.
law should always be state. Lock that into your brain. Criminal laws should always be state laws. No, although I can understand why people would say that.
It would be hard to draw the line, especially with the Interstate Commerce Clause, on how we would enforce someone stealing your identity in Oklahoma.
Well, we have that problem right now because what you'll see, and I've had clients that have this problem. They have a business, and somebody in India who's very close to another company in India, and the company in India, number one, will make a complaint about this company, and it'll damage their reputation. You can't get anybody to remove this complaint. It's very difficult. You have to pay Google. You have to go through a lot of hoops to get this stuff removed. And then you get a letter from India company number two that says, if you will pay us money, we guarantee we can get company number one to take this off. Well, they're just going to go pay them, right? So company one and two are just partners in crime and extorting money from you, and it's really hard to fix.
Yeah, it's really hard to fight. I think that this is an example of that future case of the micromanaged blockchain, or a distributed ledger that's keeping an immutable, unchangeable record of business transactions. So when things like that occur, we can point directly back to the chain of record and determine whether or not that relationship even existed.
Right.
That kind of accountability is far off in the future, though, and it's dependent on cultural changes and acceptances of systems that give us insight into operations that we may not be ready to accept yet.
Well, it's an evolving field,
It's
going to be evolving for the next foreseeable future. So it seems like a good note to end on. We appreciate your time, and I want to say thank you to Brian for coming in.
Thank you for having me.
Is there a website, or where should I send people when they need your help?
I mean, I'm all over the internet. You can find me on LinkedIn. Really, my best advice would be to reach out to your local trusted attorney if you find yourself in a situation where you believe that you've been cyber squatted, or a victim really of any kind of violation of your personal identity rights. It's always best to start at square one and make sure that what happened is actionable and that you have ground to stand on, and then approach it smartly. The last thing that you want to do is get into a fight with the internet.
We used to have this phrase that says, "Don't ever get in a fight with the publisher because he buys ink by the barrels." Okay, we don't even need to buy ink anymore, right?
We don't.
We have endless numbers of ones and zeros, and so thank you, Brian. It's Brian Kissel. That's how I said that right?
That's right. Thank you very
so
much.
Of Calypso, we appreciate your time. Feel free to holler us. And the last bit I'll say on this is, we attorneys are so much cheaper on the front end than the back end. If you're going to do something that's dubious, come and ask us. If you think that the answer is going to be no, you shouldn't do that, then you can just say, no, I shouldn't do that. But there may be a way of doing it so that you're not breaking the law or defaming somebody or getting into trouble. Come talk to us before you do these things.
Every single one of my clients that didn't talk to an attorney at first got one after the fact.
Much more expensive. Much more expensive. So thank you for that. We'll see you again next time, White Hat Law. Soon.
Well, that's a wrap, folks, and we want to thank you for listening to the White Hat Law Show here with Warren Nord. To find out more about Warren, check him out at nordlaw.com. See you next time.